The Supreme Court has just delivered a ruling of seismic magnitude, shaking the foundation beneath Donald Trump in a way few anticipated. This is not merely another legal defeat. This is an event that has left the former president and his entire legal team in apparent shock, scrambling to comprehend the full implications. Reports suggest Trump is spiraling, struggling to grasp that a hidden judicial confrontation has suddenly emerged from the shadows. Before we unpack what this ruling means, consider subscribing and turning on notifications. This is where you get unfiltered, in-depth analysis of legal developments that mainstream media often sidelines. Every detail matters, and the next 72 hours will be crucial. Here's what makes this case extraordinary. The Supreme Court has ordered Trump to hand over financial records, internal business communications, and highly sensitive documents. Materials so significant that even members of his legal team were reportedly unaware they were within the court's reach. This isn't a routine denial of a motion or a procedural dismissal. This is the highest court in the country stripping away layers of secrecy, compelling access to information that could reveal a previously concealed level of potential criminal exposure. What's almost impossible to grasp is how the Supreme Court conducted this entire process in near total secrecy for more than a year. Even Trump's lead attorneys reportedly did not know a grand jury investigation of this scale was underway. There were no public filings, no announcements, no media alerts. The case moved entirely out of public view, a silent legal battle operating behind closed doors, while Trump believed he understood the full extent of his legal exposure. And then suddenly, the ruling arrived. No warning, no time to prepare. Trump and his team went from confidence to shock within hours. The Supreme Court had not only rejected his claims but revealed a hidden judicial front he never knew existed. This is not just another lawsuit added to Trump's growing list of legal challenges. This is a separate, independent investigation, distinct from the classified documents case in Florida, the January 6th prosecutions, and the Georgia election interference inquiries. It is effectively a fourth front, one that surfaced without public awareness, and one that Trump must now confront immediately. The Supreme Court's ruling is extraordinary, not just for its content, but for its method. Normally, the court operates with full transparency. Cases are public, oral arguments scheduled months in advance, legal briefs available for scrutiny. Secrecy is rare, reserved for matters of grave national security or scenarios where public disclosure could cause immediate, irreparable harm. Yet in this instance, the justices chose to proceed in complete confidentiality. The sealed grand jury subpoena, now revealed, had been active for over a year. It demanded Trump's financial records, internal business communications, and documents described as having profound national significance. Trump was served under strict confidentiality, barred from discussing the proceedings publicly, even with allies or the media. His attorneys were bound by the same silence. Trump responded with his familiar defenses: presidential immunity, executive privilege. The implications are enormous, touching on potential foreign influence, undisclosed diplomatic dealings, or other national security concerns. The third category is perhaps the most explosive: documents connected to efforts to obtain anything of value from foreign sources in connection with electoral activities. Federal law prohibits foreign contributions to U.S. political campaigns, and soliciting or accepting them is a serious criminal offense. If evidence emerges that Trump or his campaign engaged in such conduct, the consequences could be historic. Trump's legal team now faces an almost impossible task. They must locate, review, and produce potentially millions of pages of documents, financial, political, and personal, while determining what is legally privileged, all under a strict 72-hour deadline. There is no time to pause for staffing changes, appeals, or procedural maneuvers. Every moment counts, and any misstep could be catastrophic. The stakes are clear. Compliance risks exposing potentially devastating evidence. Defiance risks immediate incarceration. This is a trap with no middle ground, and it is the culmination of a year-long legal battle conducted entirely in secret. Trump's familiar playbook, delay, attack, and obfuscate, is effectively neutralized. The reaction inside Trump's camp was reportedly explosive. Sources indicate that upon learning of the Supreme Court ruling, Trump shouted at his attorneys, threw objects, and demanded answers about how such a secret proceeding could advance without his knowledge. His legal team was thrown into immediate crisis mode, scrambling to identify which documents fell under the subpoena and how to meet the impossibly tight 72-hour deadline. Two attorneys reportedly considered stepping away from the case altogether, citing ethical concerns about representing a client who may have withheld critical information or exposed them to potential violations. Bringing in new counsel at this stage would be nearly impossible, as any replacement would need months to get up to speed. a luxury unavailable under the court's uncompromising timeline. Meanwhile, a cooperating witness who had previously provided evidence in other investigations may now hold additional insight into the sealed subpoena. This person reportedly has detailed knowledge of documents Trump attempted to conceal, and can testify about conversations in which Trump discussed the consequences if these materials were made public. This means prosecutors not only have the authority to enforce the subpoena, but also possess a precise roadmap for evaluating Trump's compliance. Trump himself reportedly attempted to regain control of the narrative. Within hours, he posted on Truth Social, attacking the Supreme Court justices, including Chief Justice Roberts, calling the ruling a covert assault by corrupt judges and declaring the order unconstitutional. Legal analysts quickly warned that such statements could be considered direct evidence of intent to defy a lawful court order, increasing the likelihood of contempt charges if he refuses to comply. This is a moment of unprecedented pressure. Every familiar strategy Trump has used, attacks, delays, appeals, has been neutralized. The Supreme Court has closed every legal avenue. The clock is ticking, and the next 72 hours will determine not just how public opinion is already shifting. Recent polling indicates a growing number of Americans, including a substantial portion of Republican voters, believe Trump must comply with lawful subpoenas, regardless of political loyalties. The principle that no one is above the law is resonating strongly, even among those who have long supported him. Democrats are expected to seize on this moment to argue that Trump is unfit for executive office. A candidate who actively resisted providing documents to federal prosecutors cannot, they contend, be trusted with the powers of the presidency. Meanwhile, Trump faces the challenge of rallying his base around a legal battle that the public only now fully understands. The very secrecy he relied upon to control narratives has turned against him. Every decision over the next 72 hours will reverberate politically. Compliance could be seen as concession or weakness, but defiance risks incarceration and an unprecedented constitutional confrontation. Trump's campaign, strategy, and messaging are now under extraordinary pressure, forced to react to legal developments that were deliberately hidden from him until the Supreme Court acted. This is a historic inflection point. For the first time, the highest court in the nation has compelled a former president to confront a legal reality he could neither predict nor influence, under conditions that leave no room for delay or obfuscation. What makes this ruling truly historic is not just its immediate impact on Trump, but its constitutional and legal significance. Experts note that the Supreme Court has demonstrated that even a former president is not above the law. Claims of absolute presidential immunity and executive privilege can be overruled when the material sought falls outside the scope of official duties. This case also establishes a powerful precedent for the future. Confidential grand jury proceedings can reach the Supreme Court, and the justices can issue binding rulings that compel compliance, even against the nation's highest-ranking former officials. The court has shown that secrecy, when warranted by national security or critical interests, can be preserved while still ensuring accountability. Legal scholars, including Harvard's Lawrence Tribe, suggest that this may be the most consequential Supreme Court action involving a former president since United States versus Nixon. Unlike Watergate, where the legal battle unfolded publicly over months, this case proceeded entirely under seal, revealing just how far the courts can go when urgency and national security intersect. The national security dimension raises additional questions. The identities of certain foreign nationals remain redacted, and the secrecy surrounding the investigation suggests the material may touch on intelligence, counterintelligence, or diplomatic concerns that the public cannot yet fully grasp. What prosecutors and national security agencies know and for how long is unknown, but the deliberate concealment underscores the extraordinary seriousness of the matter. For Trump personally, the ruling leaves no room for familiar strategies. Delays, procedural maneuvers, and appeals are no longer viable. The Supreme Court has set a hard deadline and made clear that non-compliance will be met with immediate consequences, including